5 minutes.
Thank you, Mr. Chairman. Thank you, Attorney General Holder, for being here. Listening to the answer you had from the former chairman, it seems to me when you see that folks did not follow policy, did not follow your directives, and we're here 13 months after you found out that an agent was murdered for policies that you did not support, and we find out you've not fired a single individual. We find out that you have not rebuked any staff members. Heck, you haven't even put a letter in people's personnel files saying that they on their watch, acted and an agent was murdered. That is absolutely absurd from this side of the dais. And so I ask you, why have you not taken steps to make sure this doesn't happen again?
Well, I have taken steps, certainly with regard to—
You told people that you were mad, you were upset. That, to me, is silly. You've not taken action. You've not fired anybody. You haven't changed policy because it's clear you didn't enforce the policy before. You didn't even know. You're saying you didn't even know about it. So it strikes to me as incompetence in terms of management.
Well, I'm not sure you understand how the Justice Department works. I didn't express the fact that I was mad or that I thought it was silly. I issued a directive that said the Attorney General of the United States says that this policy, this kind of technique, is inappropriate and should not be followed. We're still in the process of trying to determine, the Inspector General is trying to determine where this policy originated. We know that it started probably in the ATF office in Phoenix. It was approved by U.S. Attorney's Office in Phoenix. Now, exactly who the people were who actually approved the technique, we're still in the process of trying to work through. But that's not all that I've done. I've made personnel changes with regard to leadership positions. We have moved people around. We have instituted a series of policies now that I think are designed to make sure that that doesn't happen again.
So an agent was murdered, and your action is to move people around. That seems to me to simply inconvenience people, not to rid them of federal employment.
Well, to the extent that we find out who precisely was involved in this or who gave that order, I can assure you that unless there is some truly compelling circumstance, that person, those people will be removed from federal service. But that's not all that we've done with regard to the murder. We're in the process of investigating that murder, and the people who are responsible for it will be held accountable, and I expect that you'll hear something about that relatively soon.
Relatively soon, 13 months later?
No. You will hear, well, these matters—
It's 13 months after the fact, sir. That's what I'm saying. At what point are you going to take action?
As soon as we are in a position to make arrests and hold people accountable, put them in a court of law, and try them with maximum charges. These are not cases that—
Is that likely this year?
I think that's likely this year.
Is it likely in the next 6 months?
Yes, I think it's likely in the next 6 months.
Could you see that happening this quarter?
When does this quarter end? I don't know.
March 31st.
It's possible.
Possible. Okay. 13 months later, we have possibility of somebody actually being punished for an agent being killed. This is absolutely absurd. Mr. Chairman, I yield the balance of my time to you.
No, it's not absurd. It takes time to build a case that you're going to be able to take before a jury with a high standard of proof, convict somebody, hold them accountable. You don't want to go into court and put yourself on a time limit and at 3 months say, let's take whatever we got and get into court, because some critics are going to say we're not acting fast enough, end up losing the case, and then the people who are responsible for this heinous act are not held accountable. We go into court when we think we have cases that are ready to go. I'm not putting any pressure on people in that regard other than to do it as quickly as they can, but to do it as thoroughly as we can, and so that we bring the best possible case that we can.
I thank the gentleman for yielding. And quickly following up, no, it isn't. Mr. Lanny Brewer is not going to be criminally indicted or anything else, but when Mr. McHenry was asking about holding people accountable, he was really asking about people that work for you. Now, is your management style a hands-off or is it a hands-on? Do you want to know what's going on, or do you want others to handle it and brief you relatively high level?
Well, I think I've got a hands-on style.
Okay, well, if you have a hands-on style, have you read any of or been fully briefed on any of the wiretaps, including the March 10th wiretap in this case?
These wiretaps are very voluminous, read well kinds of things. I have not read them.
Okay. Well, Kenneth Melson told us, and this has been publicly reported, that, in fact, he was sick to his stomach when he discovered it. This was approved by Lanny Brewer's office. Indications are that your chief deputy knew about this. I mean, it comes through criminal division at some point. The question is, will you, or isn't it appropriate that you know about these wiretaps so that you could know what former ATF, acting ATF director knew, which was these wiretaps are reasonably believed to be sufficient in what they disclosed, that many parts of this operation should have stopped sooner, and that people were saying that at DEA and other places, and that the Office of Criminal Division, Lanny Brewer's division, if you will, knew or should have known that. That's the kind of thing Mr. McHenry was asking about, is holding people accountable, whether they're career professionals or political appointees. Are you prepared to do any of that prior to the Attorney General's final report? Because you haven't done any so far as we can tell.
I think you mean the Inspector General's report.
I'm sorry, the Inspector General's. I sorry, Mr. General, I keep confusing the two generals, but yes, I very much know your Inspector General's report, which seems to be the reason for the delay in executing on disciplinary actions.
Well, I mean, you've packed a lot into that question. I mean, I think first off, there's no indication that Mr. Brewer or my former deputy were aware of the tactics that were employed in this matter until everybody, I think, became aware of them, which is like January, February of last year. The information, I'm not at this point aware that any of those tactics were contained in any of the wiretap applications. And I will say this. To the extent that those wiretap applications have been shared, that is in direct violation of court orders. And if I find that somebody in the United States Department of Justice has shared the contents of a wiretap application, that will be something that will have to be looked at. There is a wide variety of things, information that we can share, but I'm not going to go against sealing orders by a court with regard to a wiretap application. And anybody who reads that material or submits that material for people to examine does so at their peril.
I appreciate that. For the record, members of Congress are not covered by that prohibition. Members of Congress are not in any way under that order. In fact, if we receive the information from whistleblowers, just like the press, it is in fact legitimate for us to know it and to act on it in our investigation. We are not covered by that Federal court order. Your law enforcement people related are. Before I yield, did you want to respond after you got a note on that?
With all due respect, Mr. Chairman, I think that direction that you just said about the media and Congress and court orders is really incorrect, and I think you act at your peril if you think that's the truth.
Well, certainly we would say that the release of information from our testimony of Kenneth Melson that appears to have been leaked to your people also would be inappropriate, but we'll get to that at another time.